Hello, and thank you for joining us at the latest instalment of the William Buck CPE program. I'm David J. Barilli.
I'm Garth O'Connor.
And we form part of the Restructuring and Insolvency Division here at William Buck. Today's session, we're going to go through members' voluntary liquidations and the voluntary deregistration process, how they might be of use to both business owners and their advisors. And from an insolvency practitioner standpoint, I guess we've certainly noticed a growing need for these services in recent times. We've worked with both business advisors and tax advisors on these types of engagements, and it's usually motivated by some of the tax benefits that each process brings to light. So throughout the session, we'll refer back to a case study which covers off on some of the most common issues we see here, and we'll touch on some of our recent experiences in the space. I'll start off with a brief summary of each process and how they differ. A members' voluntary liquidation, otherwise known as an MVL or a solvent liquidation, is a process designed to help directors and shareholders wind up the affairs of a company when there's no further use for that business entity. A liquidator is appointed to formally wind up the affairs of the company, and once this process is then finalised, ASIC will then proceed to deregister the entity from its business registers. On the other hand, the voluntary deregistration regime is basically refers to an application with ASIC. Essentially, a lodgement is submitted by the company's directors requesting that ASIC deregister the entity from its business registers. They then need to ensure that the ASIC annual fees are paid up to date, and once approved, the company will cease to exist as a legal entity, and ASIC will proceed to deregister it from its registers within about 2 months of having been approved. So although each process is very similar in the actual outcome achieved, there are a number of factors which will determine which is the most appropriate in any given scenario. But before we get into the nitty-gritty, I thought it would be useful just to touch on some of the more basic reasons why we might go through either an MVL or a voluntary deregistration in the first place. As you can see up on the screen, there's a number of factors, the first being corporate streamlining or simplification. Now, this is often a requirement of large conglomerates, listed entities looking to reduce their compliance costs or simplify their group structure. Each process provides a good way of actually disposing of dormant entities which no longer have any purpose to the group and can often involve both a mix of MVL and deregistration. This is particularly useful when you're dealing with a complex group structure or a large multinational. The second reason we often see is usually retirement or exit planning of business owners. And this is probably one of the primary business cases we see, particularly for MVLs in our space. Generally, this is when an owner is looking to just plan for their retirement. For example, they may have just sold their business and simply now looking to wind down their operations or clean up their corporate shell. We also see this situation with large international businesses looking to exit a particular region or market, or even divest a particular business unit, perhaps because it's underperforming. Thirdly, we've got risk mitigation. This is specifically relates to the MVL process. A common driver of the need for MVLs in this situation is where a client is looking to mitigate its exposure to a risk or a potential creditor claim, or an external review for that matter. There are some obvious benefits to an MVL, including added difficulty and cost in reinstating an entity once it's gone through this process. And this often suits clients who are looking to act quickly and put a full stop on any looming issues. And finally, and one of the most prominent reasons we usually see for an MVL in particular, are tax benefits. There are a number of different tax treatments for distributions which are made by a liquidator. The general rule is where a liquidator can accurately determine the origin of funds that are made from a company, then using the company records, those distributed assets maintain their character for the purposes of any distribution. From a high level, there's a number of concessions, small business CGT concessions, including the 15-year exemption, the 50% active asset reduction, the small business retirement exemption, and the small business rollover. And we also have pre-CGT reserve exemptions, which essentially when a distribution comes from a liquidator rather than as an ordinary dividend, the funds will then retain the character of profit or income in which it was first derived. As a basic example, if a liquidator's distribution is made from profits realised from a pre-CGT exempt property, that distribution would then retain its CGT exempt status in the hands of the shareholder. This can obviously result in some pretty substantial tax savings for shareholders overall. So what's the difference between the two regimes? Starting with the MVL process, directors make a declaration that the company is solvent and will be able to pay all liabilities within 12 months. Shareholders resolve to wind up the company via special resolution, which is 75% of all votes cast by shareholders. And a formal liquidator is then appointed to distribute the assets, if there are any, and finalise the affairs of the company. On the other hand, in the case of voluntary deregistration, the company or its directors apply for voluntary deregistration subject to specific requirements under the Corps Act. Shareholders must consent to the deregistration, and the company must not be carrying on business or trading. It also needs to have assets of less than $1,000, and this renders many companies ineligible in the first instance, as well as having nil outstanding liabilities, fees, or penalties dues. The company must not also be a party to any legal proceedings on foot. So as you can see, those final three limbs can often knock out the deregistration process for an entity in the first instance. Now, we've developed a bit of a case study, Garth, which I thought would run through for the benefit of everyone. We've got the case of Cramerica Industries, which is a new age pizza restaurant where customers are given the opportunity to make their own pie. Now, after a few years of profitable trading, Cramerica's revenue has seen a gradual decline following the rapid growth of at-home food delivery services. Mr. Cosmo Kramer is the sole director and shareholder of Cramerica, and he's decided that he would prefer to exit the pizza industry and reallocate this funding to one of his other successful businesses. Mr. Kramer comes to William Buck to discuss some of the solvent wind-down options that are available to him. He's also flagged that there is a possible public liability claim against the company after there was an oil spill in the restaurant which saw a customer fall and injure themselves. At this stage, there's been no claim brought against the company, and the company does hold public liability insurance policy. So that's important to note for later. So having said that, let's take a look at some of the benefits and the risks of the MVL process in particular. In the first instance, the MVL process reduces future exposure for directors and officers in relation to potential creditor claims or legal proceedings which have yet to materialise. It's very difficult to reinstate a company once it's gone through an MVL process, as this requires a costly court application. There's also a formal tax clearance process, and this obviates the risk of the ATO coming back and putting its hand out down the track once the process has all been finalised. An independent liquidator is appointed to manage the affairs of the company and the winding up generally, and this is a great perception benefit of the process as it adds that level of independence to the process itself. There's also relief from certain reporting obligations, such as that to complete an annual or half-year audit, which would otherwise be mandatory for applicable entities. But the process also does have some drawbacks. There are risks. It can take between 6 to 9 months in our experience due to statutory notice periods, clearance requirements, and the timing can be quite tricky to navigate, particularly as the ATO needs to provide its clearance, which is out of the liquidator's control in many instances. It also is a more expensive process than deregistration and involves the fees of a liquidator and certain statutory requirements and costs. On the other hand, we have the deregistration process. It's a simple, quick and efficient process, as it's barely or merely an application lodged with ASIC and can be usually done on the same day. It is inexpensive compared to the liquidator's fees, but it does have its drawbacks. The company can be reinstated more easily to face claims arising post the deregistration, and ASIC can actually reinstate a company upon request from an interested party without a court application required. Directors and officers can be appointed at the time of deregistration and are also reinstated to their office holdings, so they can be pulled back into management responsibility without their consent. And directors are required to also make a statutory declaration as to the level of assets, liabilities, etc. of the company, and any misleading conduct or answers in relation to this disclosure is punishable by fine, imprisonment if found to be false. So linking back to the case study, Garth, in this instant, Mr. Kramer has made the decision to cease trading about 3 weeks earlier. He's been reporting losses at this stage, and his tax accountant is working furiously to get the management accounts up to date and all his outstanding tax lodgements. Kramer did have a major asset, which was a commercial grade pizza oven, which he then sold to his neighbour Jerry for $100,000. He's used $25,000 of those funds to repay outstanding entitlements from employees and his trade creditors. So this leaves $75,000 in Kramerica's bank account. He says he needs to access these funds right away for cash flow purposes in his other businesses, but he just can't wait for that standard MVL processing time, which we mentioned earlier.
DJ, we've got Mr. Kramer sitting in our offices. He's wanting some guidance on which path to take. Can you take the audience through the considerations that we would look at based on the risks and benefits and the specific facts of Kramer's circumstances?
Well, firstly, we have to look at those circumstances and factual circumstances as they lie. And in Mr. Kramer's situation, he's obviously got assets in his bank in the form of cash, and he also does have a public liability claim. So in this scenario, I think the MVL process would be most appropriate for Kramerica's circumstances. Firstly, he won't meet the deregistration requirement for that disclosure that the company does have less than $1,000 in assets. And the risk of that potential public liability claim looming does provide alarm bells that a deregistration process might not be fitting to fully protect his risk exposure.
So we have the tricky little situation in that Mr. Kramer wants the cash owed to him as shareholder of the company immediately. Is there any way that we can dance around the timing requirements of a distribution by a liquidator to bring that forward?
I'm glad you asked, Garth. Now, remember, the company does have that $75K in cash sitting in the bank account after selling the pizza oven. And Mr. Kramer has obviously said he does want that money now, but can't wait the 6-month plus processing time of an MVL. So given we anticipate the director will need to put some money aside for liquidators' fees, what we could do is get $65K in residual cash and provide it to Mr. Kramer immediately and record it as a shareholder loan on the books of Kramerica. Now, this would be distributed in specie at the conclusion of the process. You might ask what that means. A liquidator has the power to distribute an asset in its present form rather than having to actually realise it and distribute it as cash, as long as this is within the company's constitution or agreed by resolution of shareholders. Hence, the cash can actually stay with the shareholder, and the liquidator will then distribute or net off the shareholder loan at the conclusion of the MVL. However, it probably is worth noting at this stage, these sorts of loans can have some tax consequences, particularly Div 7A is a real risk in this situation, particularly if the MVL isn't settled within approximately 12 months. So that's just something to keep in mind when advising clients, particularly with an MVL strategy, although I will say the MVL process is designed to be wrapped up within less than 12 months, and that's why you make the declaration in the first place. So just running through the actual appointment process itself, there are a number of steps we need to go through to effectuate the appointment. The first being the meeting of directors. Now, we need to ensure that there's appropriate quorum is met, and that's a number of people present at the meeting who are entitled to vote. At this stage, the directors would consider any proposed resolutions to be put forward for shareholder approval. We then would move, the directors would then move to declaring a declaration of solvency. And this is executing a document that essentially says the company can pay all of its debts within 12 months. This document must be lodged within 1 day prior to the notice of meeting going to members, which is the next stage in the process. So then we need to call upon the shareholders. We require 21 days notice of a meeting to shareholders unless you get consent of 95% of shareholders, or the Constitution allows, and we call that a consent to short notice. Once we've got that consent to short notice, or we allow the 21 days to actually elapse, we can move to having a meeting of shareholders to finalise the position and the future of the company. Now, this meeting needs to be held within 5 weeks after making a declaration of solvency from the directors, and it needs to consider a number of resolutions, both ordinary, such as remuneration of the liquidator, and special resolutions such as that of the winding up and the ability of the administrator or the liquidator to distribute in specie. A couple of other housekeeping issues are worth noting. There may be differing shareholder classes enshrined in the constitution of the company, which may affect the distribution. There can also be different entitlements to vote at any of these meetings, voting options, and notice requirements, which may alter the specific requirements prescribed under the Corps Act. But as in any of these MVL engagements, we find that planning is key, and it's crucial to conduct a detailed pre-appointment review before commencing the process in order to minimise the overall costs to the client and prevent any additional out-of-scope works being required. So as you can see on the screen, we've developed a bit of a planning checklist which covers many of these issues, which generally end up blowing out the budget, you might say. For example, in the first instance, we need to check that there's no active utility or telecom services that might need to be disconnected or transferred. We ensure that there's no outstanding debtors that need collection, contingent assets or liabilities which may need to be realised or discharged, any insurance policies that might have been taken out in the last 12 months which relate to potential claims such as public liability. Motor vehicles which are registered with state authorities may also need to be sold or transferred. Paper or electronic books and records, including financial records such as Xero and MIBE, is also a consideration, as sometimes they require storage or ongoing compliance with a number of legislative requirements. And finally, we make sure there's no outstanding legal matters which may need attendance in court or settlement.
DJ, having run through a number of MVLs over the past few years, what's the one thing that pops up regularly and does cause the cost blowouts if not dealt with prior to the appointment?
I think the most inconspicuous one in terms of utility and telecom services is one that generally does end up blowing the budget. I'm sure most of our viewers can resonate with dealing with telecom and utilities providers. It's not the quickest or most efficient process, and often requires a lot of manpower, where otherwise, if you had planned ahead and transferred services or cancelled them prior to the appointment, this can result in a particular or a substantial cost saving for the client overall. So I would suggest, if you do have a phone number that you need to port or a service that you need to cancel, we look at it prior to the MVL commencing. So tax clearance is the next topic which I'd like to talk about, which also relates to the MVL process in particular. It's the most prominent reason for delay in our world, particularly in finalising an MVL, and that's because we need it. We need the consent of the tax office to finalise any distribution to shareholders. Now, a liquidator needs to bring up to date any outstanding income tax returns, BASs, fringe benefits returns, or any other real lodgements up to date before the ATO will actually provide clearance to a liquidator. This means even if a company has actually ceased trading in a prior financial year, if it does enter the new financial year having not made the appointment of a liquidator into an MVL, the ATO will still require submission of those lodgements, even if they're nils, as a matter of process. So often in this scenario where we tick into the new financial year, we have gone the route of making paper lodgements for income tax returns in particular, and this is generally because the tax software isn't available at this point in time early in the financial year. This can add, we've been quoted an additional 50 days to the actual process overall, so it's a substantial delay in timing. So it's always good to plan ahead and make sure that we've got our ducks in a row prior to commencing the MVL and making sure we've got our timing up to scratch. Generally, we've seen tax clearance taking anywhere between 3 and 6 months to receive from our initial request. And finally, I did just want to touch on the liquidator's requirement to actually publicly advertise for proof of debts or claims before making this distribution to shareholders. This does allow an opportunity for any unknown creditors to come forward and protects the company, the liquidator, and the directors overall should someone come out of the woodwork after the process having been finalised and asserting to have a claim.
So it's worth touching on a couple of scenarios, a couple of outcomes that could occur based on our case study we touched on earlier in the session. Scenario one, the liquidator is appointed. They go through their process of seeking tax clearance and all their statutory lodgements. Ultimately, no claim is issued in relation to the injury claim. No further proof of debts are submitted as part of the public advertising process. So the liquidator at that point, they've got tax clearance, can proceed to distribute the surplus assets to the shareholders, and a final distribution statement is prepared to Mr. Kramer. That's your straightforward scenario. It's streamlined, it's efficient. Mr. Kramer will get his loan, a distribution in specie. If there was any tax benefit, he would get that as well. Scenario two sort of just touches on the power of the liquidator to make rulings and again streamline the process if there's a contest about claims. So in this case, the liquidator receives a solicitor's writ in respect to the alleged damages claim for the injury. The company's insurer refuses to cover the customer for the slip due to a negligence exclusion. At this point, the liquidator has a decision to make on whether to admit the claim or reject the claim, which will obviously impact the ability to distribute surplus funds to the shareholders. The liquidator in this instance holds a role that's been described as a quasi-judicial role. So they do hold great power to make a ruling on a claim. The only recourse a creditor at that point, once the liquidator has made their claim either to admit or reject, would be to run off to court and seek that the court overturn that ruling, which again creates delay, creates added cost. So it's just a streamlined process to potentially deal with a contentious claim or issue. Scenario three, it starts out the same as scenario one. No claims received, distribution made to shareholders, company is ultimately deregistered. The former liquidator receives a letter sometime after the company has been deregistered with a solicitor flagging that there is a potential claim that would be covered under the insurance policy. In order for that person or that party to access the insurance policy, the company would need to be reinstated. So again, there's a court process to go through. However, rather than directors being dragged back into the management of the company, having to bring all the outstanding lodgements back up to date, the former liquidator would be reappointed, and all they would do would be sit in the background. They would get leave from the ATO to not bring all those lodgements back up to date, sit in the background while the party sought to access a payout under the insurance policy. So it just allows the parties connected to the company to move on, and any fallout down the track will ultimately be dealt with by the parties that would benefit and the liquidator that was incumbent at the time the company was deregistered.
Thanks, Garth. It's a great rounding out of the outcomes to any MVL process. So we'll just leave our audience with a couple of practical tips when dealing with the MVL process in particular. Firstly, check if the shareholder is a resident for tax purposes. There actually may be a requirement to withhold foreign withholding tax when you are distributing to a non-resident shareholder. So this can trip up the shareholders in certain circumstances if you haven't planned ahead for that. Secondly, we suggest that you check that the company if it's part of a consolidated group for tax purposes, and whether it's got a valid tax sharing agreement or funding agreement. If it does, the company may be joint and severally liable for tax debts of the consolidated group, and this can also lead to delays in the provision of tax clearance by the ATO. Finally, and last but not least, failing to plan is planning to fail. Dealing with live assets, active services, and outstanding liabilities or compliance obligations prior to the appointment is the most streamlined and effective way of dealing with the MVL process in general. This will overall reduce the cost and overall time required to complete the MVL process. So we've got a couple of questions, Garth, just to round out with the audience.
Excellent. So out of the options listed on your screen at the moment, being assets of less than $1,000, declaration of solvency, company not carrying on business, or nil outstanding liabilities, which of the following is required to actually commence an MVL?
Good question, Garth. I'm going to go with the declaration of solvency by directors. Now, the reason for this is, remember, we're talking about an MVL here. A being assets less than $1,000 is specifically relevant to the voluntary deregistration process, so we know that doesn't affect this process. The company not carrying on any business is also relevant to that process, being the deregistration process, and same goes with the nil outstanding liabilities. The declaration of solvency is only conducted in an MVL process, so we know that it is one of the first requirements to commence and get that process underway.
All right, second question. So which of the following are benefits of the voluntary deregistration process? Is it A, reduces the exposure to future claims? Is it B, makes it more difficult to reinstate the company? Is it C, it is an inexpensive process? Or D, all of the above?
Great question, Garth. Now, remember, this time we're talking about the voluntary deregistration process in particular. When we speak about reducing exposure to future claims, we've got to remember that this is a specific benefit of the MVL process, not the voluntary deregistration process. And this leads into answer B. The MVL process makes it quite difficult for a company to be reinstated because it requires a costly court application, which then obviously knocks out question D, all of the above, because we've already got two answers which don't meet the criteria. So I'm going to go with C. It's an inexpensive process. Remember, the deregistration process doesn't involve those costs of a liquidator. It's merely a cost paid to ASIC, essentially. So even though it does have its pros and cons, it is a rather inexpensive process in comparison. Last question, Garth.
Final question. So what we want to do is place these MVL appointment process steps in chronological order. So we have a meeting of members, and these are all steps required to effect an appointment. So we have the meeting of members, a declaration of solvency, a meeting of directors, and a notice sent to members.
If you were paying attention a couple of slides ago when we had the chevron with some of the arrows, you might have picked this up if you've got a great memory. But thinking logically, I'm looking at the meeting of directors first. Now, that's the process of getting directors together to actually put forward the proposal to wind up the company to shareholders. So they obviously have to meet before the shareholders can meet. The directors then need to submit that or execute that declaration of solvency. That is the job of the directors, to state that the company can pay its debts within 12 months. So before we get to any shareholder meetings or member meetings, we need to get the directors all in order. We then move on to providing notice to members, because you obviously can't have a meeting of shareholders without providing notice. And remember those notice requirements, 21 days, unless we've got consent. And finally, the shareholders are ultimately the ones that are going to place the company into liquidation or wind up its affairs. So we have that step last in terms of the shareholders effectuating a special resolution to do so. That pretty much takes us to the end of our latest CPE instalment. So I'd like to thank everyone for attending today and joining us. And we hope you've gotten something out in regards to the MVL and deregistration processes. Thank you.